box. We will also have an evaluation at the end of the session, so we would appreciate you completing that survey. It might take you a couple seconds or a couple minutes maybe just to fill out those questions. Are really important for us to get your feedback about the session today, but also opportunity to give us ideas for future webinars. We do take your suggestions into hand when we're planning these sessions, as well as in the future. So before we begin, I'd just like to give our land acknowledgement. We acknowledge that the lands that we live and work on are the territorials of many nations and home to many Indigenous peoples. There's a new understanding in our interactions and engagements with the land and its people, and we endeavor to honor them by strengthening our relationships and responsibilities toward them. While there's an important work being done by many nations and allies to ensure the continued thriving of our communities and knowledge systems, we recognize that our knowledge and way of doing things may not be the priority as we work towards a safe, abuse-free Ontario for all seniors. So just to give an overview of our presentation today, Denise, our speaker, will talk a little bit about the criteria for an investigation, areas that they investigate, the steps that they take in terms of from intake onto the process of investigation, possible outcomes of investigation. They will be obviously different based on the individual circumstances, and also to talk about other options besides maybe going through the OPGT investigation office that we can do as community members, as agencies, to mitigate the risk of older adults in the community. So I'm looking forward to this presentation, and I'm sure you are as well. For those who are joining us for the first time and may not be familiar with our organization, LGBT's Provincial Ontario, our goal is to ensure that seniors have a strong voice, feel safe and respected. And we do this through our collaboration with community partners through training, education, and outreach, and advocacy work to ensure that seniors are safe and educated in that capacity to respond to seniors that in organizations are working with. So it gives me great pleasure to introduce Denise Hanovan, who is an investigator at the Office of the Public Guardian Trustee. I think I've known Denise for many years, and we've done many presentations or conferences together. So Denise joined the Office of the Public Guardian Trustee as an investigator in 2013 and has conducted many intensive, complicated investigations to help incapable people. Prior to that, she worked with victims of crime for more than 25 years in various roles, including women's shelter or crisis lines through the police and other criminal courts. So I'm pleased to welcome Denise, and I am going to go offline. And again, just a reminder, if you have specific questions as we go through, post them in the question and answer box, and we will try our best to get through them all. Just as a reminder, we understand that some people may have some personal experiences. We would like to, if there's something specific around the situation that you may be addressing, we are able to respond to those or assist you with our organization or with Denise maybe after the webinar. So because we can only get to so many questions. So if there's something more of a general question that's related to the situation, that would be very helpful, but we can't talk about personal issues first based on privacy and confidentiality that we do want to respect for individuals on the line and as well. So we do encourage you, we will be looking through for themes and context of questions. And Denise is very well versed in this capacity. So I'm going to turn it over to Denise now. Thank you.
Thanks, Rayanne. Happy to be here. Everyone can hear me okay? Okay, so the next slide basically reviews what we're going to talk about today, very briefly about the general role of the PGT and then focusing on investigations because, as Rayanne said, it's a lot of information. So the next slide basically reviews the roles. So the PGT does many things, and this is some of them. They can become, our office can become the guardian of finances for incapable people, the guardian of person for incapable people. Our office also makes treatment decisions when no one else is available under the Healthcare Consent Act for people who aren't capable in that moment. We keep a register of court-appointed guardians. Our office can become a state trustee for people who've died without a will or next of kin in Ontario. And then, of course, our investigations unit. And so before we get into that, I just want to clarify, I saw there's a few folks here from outside of Ontario. Our office only deals with the province of Ontario. So the legislation is only for the province of Ontario. So we have offices across the province for investigations, as you'll see, Toronto, Hamilton, London, Ottawa, and Sudbury. But basically, when you call our office, you could be speaking to me, and you might be calling from Sudbury, and I might talk to you about the concerns you have and take next steps from there. As you'll see, we're very busy, more than 3,000 allegations or calls about, concerns about incapable people every year, and 1,200 investigations, which includes investigations like for the people who we're already a guardian of, to go out and get information about them. Our next slide talks about the investigations we conduct for people who may be at risk in the community. So the criteria for an investigation, for that matter, would be evidence of cognitive incapacity, evidence of serious risk to the person or to their finances, and no other apparent options to mitigate the risk, to deal with that risk. And lastly, if we were looking at a guardianship investigation for concerns around personal care, not just finances, our appointment has to benefit the person. So I'm going to talk about that a little bit later on, but basically, if none of the options work and those criteria are still met, you can always call us back. So the first thing we look at when we receive a call about a concern for someone who may be incapable is mental incapacity. So the definition is that they're not able to understand or appreciate the information relevant to the decision, or appreciate the reasonably foreseeable consequences of making a decision or not making a decision. And this is kind of difficult for a lot of people to wrap their heads around. I know it was a big learning curve for me when I first started with the office. So basically, a person could be incapable of property, of finances, but not personal care. They could be incapable of both. They could be incapable of granting a continuing power of attorney for finances, but may be capable of appointing a power of attorney for personal care. So there are lots of, and I know you've had and will have some presentations. I see Shauna McEachran's here, who is a capacity assessor, and there will be presentations about that, and I'm sure there's some on the website as well. So some indicators that we may look for when we receive a call or when we're determining whether or not there needs to be investigation might be not able to understand the information like we talked about, but also inability to start or complete necessary tasks like making renovations to the home to make it safe, or paying the property taxes or the mortgage so they don't lose their home and become evicted. Changes in lifestyle that seem to be new, changes in hygiene, nutrition, or communication, disorientation to time, place, personal identity, impaired thought process, problems with simple calculations, memory loss, and perception difficulties, delusions, or hallucinations. So when I say some of these things must be new, I'm thinking more about folks who may have had a brain injury, or maybe there's concerns about whether or not they have dementia. But we deal with anyone who may be cognitively incapable. So it could be someone with a developmental disability who has challenges in these areas. So for some folks, it's much clearer whether or not there's cognitive incapacity for others, but we always have to keep that in mind. So if ever you're calling our office, we do need some sort of evidence or story about what the cognitive incapacity concerns are. So risk. Risk may be different for different people, but basically it must be significant for our office to investigate. So I mentioned earlier, if a person is at risk of being evicted, that may be significant, but it must be in relation to the cognitive incapacity. We evaluate on a case-by-case basis. And like I said, what may be risk for one person may not be for another. For instance, one person may be a lifelong gambler and is used to kind of, losing a lot of money and trying to scrape things together to start over again, versus an elderly person who suddenly started participating in scams that have to do with lotteries. Unusual and excessive spending may be a sign of risk, where it puts them at risk of not having food, like we talked about, being evicted or losing their home. Theft or loss of money, where they're suddenly giving their bank card to someone who's stealing all their money, may be a possible example of risk. Self-neglect, as we talked about, not able to provide food for themselves, or not getting the appropriate medical care, or not being provided the appropriate medical care that may put them at risk. For instance, serious seizure disorder may be one of those risks if they're not getting the appropriate medical care from a care provider. Not paying bills, we talked about not paying mortgage, or maybe not paying hydro, and they're going to be at risk for freezing in the wintertime. Isolation, deprivation of liberty, severe loss of weight might be one way to determine, especially during COVID. It's hard right now for folks to tell us what's happening when people aren't really having many visitors. So if they seem to have lost weight between visits, that's something to keep in mind. And of course, we talked about risk of eviction. So when we investigate, as I said, the criteria are incapacity, serious risk, no other options. So we're always looking at other ways that the risk could be dealt with, mainly because the public guardian's involvement must be the last resort. We must try all other possible options first before we investigate, and definitely before we make any court application or take any steps for the PGT, the public guardian and trustee, to become guardian. So some of those might be referral to community agencies. There are situations tables in Toronto and various others in Ontario that may be able to help. Contacting the bank is really important. And a lot of people say to me when I suggest that, the bank won't tell me anything. I'm not the POA, he hasn't given me permission. But it's not about getting information, it's about sharing information. So sharing the information about cognitive incapacity, sharing the information about the concerns. For instance, if somebody is using the person's bank card, the bank needs to know about that. The bank also has the ability to look at the accounts of the person and see whether or not they think there's any risk or concerns or any fraud, for instance. The bank has the ability, and I'm not saying they will, not all of them do, but the bank has the ability to restrict the account and only allow payments to come out that the person needs to have come out, so for food and for shelter. And they can also call our office if they see concerns by looking at the bank account. So that's a really, really helpful tip for any concerns about finances. Contacting the police for a wellness check is important because they have the ability to go and see the person. Sometimes they don't necessarily have the training to be able to determine if they're well. And that's where there's also, it's not on this list, but community paramedics can also assist with wellness checks. So you might want to check to see if you have them in your area because they can assess, from a more medical perspective. Having the person taken to the hospital under the Mental Health Act, especially if they're at risk to themselves or to others. That may be something to look at through a justice of the peace, justice of the peace at the courts, but the police also have the ability to take someone to hospital under the Mental Health Act if they believe there's serious risk. Trying to find family members can be really helpful because they may not know what's happening and maybe they can take steps to help. That may involve the appointment of a power of attorney if the person's capable to do so. It could also mean for finances, the appointment of a trustee. A Section 16 capacity assessment, we're going to talk about a little bit later on, but that's one of the ways that our office can become the statutory guardian of finances only for an incapable party. The local health integration network is another option to try and provide help and support for a person who may be living in their home, but needs those extra supports, like looking at bathing and a social worker to help get other supports in place, perhaps like Meals on Wheels. If it's around treatment decisions, then, and this is the last point, the Consent and Capacity Board may be available under the Healthcare Consent Act. For instance, a decision whether or not to go to long-term care can be challenged at the Consent Capacity Board if it's felt it's not best interests by a substitute decision maker for the incapable party. But the doctors can also go. Any medical professional can challenge a not best interest decision by a substitute decision maker by Form G at the Consent Capacity Board. And of course, Form C, the Consent Capacity Board, is where anyone can apply to be the health representative for someone who may be deemed incapable by a healthcare provider. And that's all, again, that information will be on the Consent Capacity Board website. So how do we get authority? One way is if Section 15, we call it, that's Section 15 of the Substitute Decisions Act, but it's under the Mental Health Act, that if a person is in a Schedule I facility, a hospital with a mental health, a psychiatric ward, and if they're deemed a psychiatric patient, then under the Mental Health Act, the physician must assess their capacity to manage finances forthwith, which basically means, within days of their admission. And if they're found incapable, they send the forms to our office and we start acting as statutory guardian. But the doctor must reassess the person before they're discharged. Because sometimes people get treatment and they may regain their capacity. And if they do, or if they don't, we need that reassessment. They send it back to our office, and we either continue with our authority or we don't if they're found capable by the doctor at that point. The next one is a Section 16 capacity assessment. And that's where the Capacity Assessment Office of Ontario, and again, there will be links at the end of the presentation, but that's available on the internet through the Ministry of the Attorney General. They have a list of all the assessors in Ontario, and anyone can arrange for anyone else to be assessed under Section 16 of the Substitute Decisions Act. This is an assessment for finances, and if under Section 16 that person's found incapable to manage their finances, the forms get sent to our office, and the public guardian and trustee start acting as statutory guardian of finances. Now, a couple things to remember. The person has the right to refuse the assessment. It doesn't mean they must consent, and that can get confusing because if the person says, oh, no, I don't need anyone, but of course the facts show that they actually do, that they're at serious risk. If they participate and don't refuse it, then it can continue. Whoever requests the assessment pays for the assessment. There may be subsidies available at the Capacity Assessment Office. So again, that's through the website, and you can call the Capacity Assessment Office for information on that. And yeah, I think those are the two provisos there. The person has the right to refuse, and whoever pays for it, whoever asks for it, pays for it. And of course, folks have the ability to challenge any of these findings at the Consent Capacity Board. Court appointment is another way that our office can become guardian. Often that can be an outcome of an investigation, but not always if we can find any other less intrusive means. But anyone can apply to be the guardian of someone else. Again, they have to have the evidence, and consulting with an estates and trusts lawyer would be important. They can also ask that our office be appointed guardian. If they don't want to be guardian, they can make an application that asks that our office be appointed. Of course, our office would respond to that and say whether or not they agreed to the appointment. And then we talked about statutory trusteeship before, where someone can apply to be the trustee for someone else and deal only with that particular income. Sometimes that's the outcome of an investigation at our office, but not very often. And continuing power of attorney for property, in very, very, very rare cases, would the public guardian consent to be appointed as someone's power of attorney for property or finances. There's a whole list of things people have to go through. So if there's any questions about that, it's important that the person speak to us before any steps are taken for that. So I mentioned this earlier, the requester pays for the assessment. There also must be no continuing power of attorney for property or a power of attorney for finances, a valid power of attorney for finances in place before the Section 16 is requested, or our office may not accept the appointment. As I said, the person can object to it. So whoever you wish to have assessed may object to it, and they have the right to refuse the assessment. And the assessor rates vary. A lot of people ask us, well, how much is it going to cost? And the easy answer is, it depends. It depends on who you hire. There are occupational therapists, social workers, doctors, nurses, who all have different rates of fees to complete assessments. But it also depends on how much time is necessary. Do they need to visit more than once? And also, and do they need to review any records or speak to other parties involved? And also how much travel may be involved. So where you live or where the person may live may affect the cost. So always keep that in mind. Sorry, this goes down to the next piece here, but there's the link for the Capacity Assessment Office. And remember that this is the only way we become guardian for personal care is through court. So this capacity assessment triggering our office to become guardian, that is only for finances. A lot of people forget that, that difference. So just want to remind you of that. So the next slide talks about when we stop acting as guardian of property. So a person could be reassessed after we become guardian. And if they're found capable, then our authority ends. As I mentioned earlier, if the doctor doesn't reassess a person who's a psychiatric patient in hospital before they're discharged, even though they may still be incapable, we lose our authority. So that's really key. I mentioned earlier that the person could challenge their finding through the Section 16, the capacity assessment, or the Section 15 at the hospital through the Consent Capacity Board. And if they overturn the finding, then we lose our authority. Someone could go to court and say, I don't want the PGT to be guardian any longer. And if the judge agrees with them, then we lose our authority. And like I said earlier, if someone is assessed under Section 16 or Section 15 of the Substitute Decisions Act, and someone comes forward with a valid power of attorney for property, then we would be giving up our authority to them. Family members can sometimes apply to replace our office as guardian of finances. So when we become the guardian of finances through the hospital or through the assessment, then family members can apply to replace us. Applying doesn't mean that they will become the guardian. There are fees involved with that, and there are requirements. So if someone is concerned about a family member applying to replace us as guardian, it's important that our office be notified about that. And of course, if the person dies, we lose authority. We don't deal with their estate necessarily. So powers of attorney for property. These can be made by anyone over 18. And I encourage all of you, if you don't have one, to consider looking into one, as long as you have someone trustworthy to appoint. Usually they take effect immediately, and they're called continuing because usually that means they continue through in any incapacity. And it usually gives the authority the ability to manage all finances, not just one particular income, but bank accounts, real estate, unless there are certain restrictions in the document. So whenever anyone calls and says, oh, I've got this power of attorney, I always encourage them to review it fully to ensure they know what it means and what it if there's any restrictions. And this is blocked out from the one that's with you guys, but the law specifies that there are formal requirements. So there must be certain ways that it's executed, and only certain people can be witnesses. So personal care decisions, there's 6 areas: healthcare, food, shelter, clothing, hygiene, and safety. Someone could be capable of some of these areas, but incapable of others. And of course, the areas that we would be most concerned about would be, shelter, safety, healthcare, nutrition. I mean, the other ones can play a factor in our investigations, but those would be the main ones that we would be concerned about. So the next slide talks about how we get authority for personal care. And as I mentioned earlier, it's only through a court order. And often that's after an investigation's been completed by us. Again, folks can apply and ask for our office to be appointed as guardian. I'm not involved in those applications, so I can't tell you too much about them. I just know it's possible. But very few people in Ontario need guardianship, like us, anyone to be guardian of personal care, especially the government. It's the most intrusive option there is. If we do become guardian, we are decision makers only. We don't have social workers, we don't have housing workers, we don't have any housing to put someone who may need a place to live. We are only the decision maker. And sometimes a capacity assessment may be required or may be done by through the investigation as evidence, or the court may require a capacity assessment before they give us guardianship. But remember that a capacity assessment alone does not make us guardian of personal care. So treatment decisions, as I mentioned earlier, that's one way that our office can make decisions about treatment only, and that's under the Healthcare Consent Act. And that's after a person's been found incapable and after the healthcare provider's gone through the list of everyone else who can make the decision for the person, and that's through the Healthcare Consent Act. And as I mentioned earlier, someone can ask to appoint our office as power of attorney, but the policy of our office for personal care is not to agree to that appointment. So our treatment decisions unit, I'm going to talk about this very briefly because I see we're almost to 1:30. There's the list of people that can make decisions before our office gets contacted. It's the healthcare provider who decides if the person's incapable, and they're the one that has to contact our office to get that treatment decision as a substitute decision maker. So we are the last resort, as you'll see. Any other relative is above us. So if no one else can be found, then our treatment decisions unit can be contacted to make those decisions. So this is outside of investigations. So the next slide talks about power of attorney for personal care. It can only be used to deal with those 6 areas we talked about. And it only comes into effect when the person's been found incapable to make those decisions. So even though I might have a power of attorney for personal care, But that person doesn't get to make any decisions until the healthcare provider says that I'm not capable of that particular decision, and then they would turn to that person. It can't be used to make financial decisions. There's a couple of other restrictions as well. Unless they are the grantor, like the person who's writing out the power of attorney, unless they're their spouse or partner or relative, they cannot provide healthcare to the grantor or for compensation. They also can't provide residential, social training, or support services for money to the person who gave them the power of attorney. So something to keep in mind. I'm not a lawyer, so I'm not going into the legalities of that, but it is in the Substitute Decisions Act, and I believe it's in the brochures on our website as well. So here we're getting into more of the meat and potatoes of the duty to investigate. This is the actual piece of legislation that talks about our duty to investigate. And it says we shall investigate if we believe the person may be incapable of property or personal care decisions, and that serious adverse effects are occurring or may occur as a result, but that we do not have to take any steps that in the PGT and the public guardian and trustee's opinion are unnecessary for the purpose of determining whether an application to court is required. So this is true for both areas. For the first section is talking about mainly finances. The second one is saying that the court shall not appoint someone if it's satisfied that there's no need to appoint a guardian. So remember, if a court appoints someone, it means that they've found that person incapable of those areas that they're appointing the guardian for, either personal care or for finances. And the court really wants to avoid doing that if possible. So it's another reason to look for all other possible options first. And it also means that our office, if we don't feel an investigation is required at any point during the investigation, it may end. So making an allegation to our office. Again, we have to have some evidence of incapacity, some evidence that there may be serious risk to them, and where there don't appear to be any other options. And the age limits are for 18 and older, we can investigate, and 16 and older for personal care, because we can't get authority for them under those ages. So again, having a conversation with the investigator when you call in is important. So every day, a different investigator is assigned to check the messages, and you do need to leave a message. It's important to leave a message with your name and number, your full name, your number, and your relationship to the person, as well as the person's name, date of birth, and address, so that we can check our system before we call you back. If we've already received allegations about the person, or if we already have guardianship for something, we need to know that before we call you back, because that will help us make our decision about what we may do at the end of the call with you. So again, we need some evidence about whether or not, why you believe they're incapable, and what options have tried that haven't worked. And we have to determine, are we the last resort? We're going to give suggestions. Pretty much every call, maybe 5 or 6 times a week, we're bumping them up, but most times we're giving other suggestions to see if there's anything else that will help to keep the person safe. As I said, we may bump it up and it may get assigned to an investigator, but that still doesn't mean that an investigation is opened. It means that another investigator who isn't dealing with 20 calls that day will call back within 5 to 10 business days to discuss it further with you and make that determination. If it can't be resolved at that stage, then the investigator may bump it up to a full investigation on our end. But remember, we are not an emergency service. So our investigations can take on average 6 to 9 months before we get any authority if the end result is that we need to go to court, because it's a lengthy process. We need the evidence to be able to show a court. And that means getting documents and records, which takes a very long time, especially during COVID. So the next slide talks about what we may consider in an investigation. We have to consider if we are last resort, if there are any other options to deal with it. Whether or not guardianship would be beneficial. So I'm going to tell you a story. We can't change behavior. So even though the person may be incapable, there may be serious risk. There aren't any other options to deal with it. Sometimes us becoming guardian is not the option that will help. I had a call from someone who was concerned about a family member who was living in a supported living environment, They were the power of attorney for property and personal care, but they had resigned because the guy was going to get evicted because he was smoking where he shouldn't, and he was being intimidating to the other residents. There would be nothing we could do to help with that. There's nothing we can do to stop that behavior that's causing him to be at risk. So, the same with drug use. I can think of another situation where the person had drug issues, but also developmental delay issues. They wanted us to become guardians so that we could make some of these behaviors stop. We can't do that. We don't have the ability to do that. So often looking at other ways, and for this young woman with the developmental disability, other ways were found by the community, and she's much safer now. So sometimes it means, talking with the investigator about, what would we do if we were guardian? That's what we need in order to become guardian for personal care. We need a plan that we can consent to that will help keep the person safe. Because remember, the court will need to know what we're going to do to protect that person if we become guardian. So yes, it's also important to consider the pre-capable wishes of the person if they were capable in their lifetime. And lifestyle choices and cultural diversity must be included. Okay, so the next step, so let's say that this does get bumped up to an investigation. The next step is for the investigator to gather information. So that would be the next slide. Yes, so this is where, right now there's a lot of telephone interviews happening because we're trying to avoid in person if at all possible to help prevent the spread of COVID. Gathering records, as I mentioned earlier, which can take a long time. And we do have authority to obtain records, including interviewing the allegedly incapable person. That's what we call the person we're investigating. The ability to access financial and medical records, and access to information from health information custodians. We may also be able to access information under Freedom of Information protection of privacy if there's risk to the person. And the people we may contact are family members, friends, neighbors, care providers, medical staff, banks, the alleged abuser, the person who may be taking advantage of the person or not providing the appropriate care, a POA or guardian. We may interview them for information, but also to get some insight about the possible risks and possible solutions. We also may ask for case conferences to happen, like care conferences. So, a group of people, and right now that's a lot easier to do because most of it can happen like this, virtually or by phone, to see if a plan can be arranged to help keep that person safe, or what services can be called upon. So the next one talks again some more about our information gathering. This is the legislation that allows us to gather some of the information I mentioned earlier. And members of health colleges have to provide information to us, their records. And we talked about most of this, so we'll move on to the next slide. So the outcomes may be that we don't have enough evidence of incapacity or serious risk. I've only had one where they didn't feel there was sufficient evidence of incapacity, but sometimes the risk can be dealt with in other ways. Again, looking at informal supports to help with that risk, having a treatment decision made under the Healthcare Consent Act. Maybe the person was able to appoint a power of attorney, or maybe there was an alternate on the power of attorney document. Maybe the first power of attorney resigned and the next person was able to act. And again, maybe it means admitting them to the hospital where they may become a psychiatric patient, and maybe the hospital is able to assess their capacity to manage finances. But even if not, even if it's just an admission on the medical floor, sometimes that's what's required. So I had a situation where there was a young man with a developmental disability who was having major behavioral issues, and there were concerns that his caregivers at home weren't providing or allowing the appropriate supports to occur. He was attending a program, and he was basically had to be locked in a room at one point due to safety concerns for the staff and the other people attending the program. The caregivers weren't cooperating with the supports that the service providers felt were needed to keep this person safe and to keep everyone else around him safe. So in consultation with the investigations unit, they did end up forming the person. And actually they called the police, who ended up taking the person to hospital. The hospital kept them and assessed him under the Section 15 of the Substitute Decisions Act, our office became financial guardian, and then they found him a respite bed, and he was able to go to another location. And he's received the supports he needs, and the parents are making treatment decisions, and he's now protected. Our office didn't need to become guardian of anything at that point because there was another plan that was worked out. But sometimes it just takes consultation with folks to figure out what might be some other options to keep the person safe. Okay, so possible outcomes. The next slide talks about maybe we or someone else arranged a capacity assessment. Our office would be the last to arrange a capacity assessment because, as you can imagine, if we're going around arranging for capacity assessments for people and collecting clients, that's really not what should be happening. We're only allowed to arrange them ourselves, the Section 16 capacity assessments for finances, if we have enough evidence that we would be able to go to court. So that takes time. So if there are immediate concerns, we're always encouraging folks to consider looking at that option if it's something that can be done, if there isn't a power of attorney, and if the person won't refuse, and if there's someone who's able to pay for it. And of course, if it's the only option left. We talked about trusteeship. That may be something that happens, and an investigation ends. Maybe someone else applies to court to be the guardian, or maybe they ask for our office to be appointed, or maybe we go to court. That can also end the investigation. Sometimes there can be other court applications that will end our investigations, though. One of them is a passing of accounts, where we ask the power of attorney or the guardian to provide an accounting of what they've done with their funds. And at that point, perhaps the power of attorney decides what steps they need to take or not take. Sorry about that slide, person. So now we're on to PGT disclosure of information. So during an investigation, we aren't allowed to share the outcome or the updates really of our investigations with other folks. The only time that we can share information as investigators is if we're giving information in order to get information. So for instance, hi, it's Denise calling from the investigations unit. I'm calling about Mr. X who lives at this address. I'd like to get some information. I'm conducting an investigation about his finances. I can disclose that information in order to get information, but otherwise, if there's information that we feel does need to be shared, we need the permission of the public guardian and trustee himself. And he is involved in basically all of our personal care investigations. The decision to go to court is ultimately made by him. So we have strict guidelines around sharing of information. So again, some misconceptions are that if an allegation is made to our office, or if we say we've got an allegation, that means there's an investigation. They are two different things. If someone makes an allegation to us, it doesn't, and they have a call with us and we maybe take some notes about it, it doesn't mean that there's an investigation open. And again, just because someone is being abused or maybe vulnerable, it doesn't mean that they're incapable. And our office can only get involved if there's evidence of cognitive incapacity. I've had people call because someone has lost their sight, can no longer get to the bank, but they're still completely cognitively capable. We can't assist with that. There would be, other services that need to assist with that. I've also had calls where they say, this elderly person is being abused by their adult child who is pressuring them to give them money and they don't want to. And again, there needs to be some cognitive incapacity. I know this is the Elder Abuse Ontario prevention program, but for us, for the public guardian and trustee, we need that evidence of cognitive incapacity or we can't assist in any way. And again, mental illness also doesn't necessarily mean that they're incapable. And maybe they're incapable of certain things. Maybe they can't, figure out how to be polite to people on the street. Maybe they have trouble picking the right groceries at the store because of, whatever may be happening for them. But unless there's cognitive incapacity that affects them in terms of serious risk, our office can't get involved. If they're eating, if they aren't being evicted, if they're paying all their bills, if there's no concerns about financial mismanagement or abuse, there probably wouldn't be grounds for us to investigate. But again, have a discussion with the investigator if you're not sure. And again, just because we investigate doesn't mean that we will necessarily become guardian. And just because the person's incapable doesn't necessarily mean that they need a guardian. Like I said earlier, people can be incapable in certain areas, but not other areas. So again, something to kind of think about, review the information that through the links in this program, in this PowerPoint, and on our website. And also if you feel you need to, please call and speak with an investigator. So there should be another slide about misconceptions. Was there another one? There it is. So the other things to remember is that if we become the guardian for someone, we can't jump them to the front of the line, for instance, for a placement, for group home placements. That's a big one right now. We can't get them to the front of the line for long-term care home placements. Like I said earlier, we can't stop them from behaving in a way that puts them or others at risk. We also can't make the family get along. So sometimes people call us because there's, disagreement among family members who may or may not be POAs, power of attorneys. We can't stop that from happening. If we become guardian, we make the decision. The law says we must consult with supportive family members and friends, and that we must consult with the, incapable individual and consider their pre-capable wishes. But we can't make folks get along. We also can't create more resources than the person is legally entitled to. So some people call and say, well, they don't have enough money, like they're only getting ODSP, and they need more money to be able to do these things that they need to do for their health. We can't create more resources. And this is where getting more supports in place to help them figure out what those resources are may be important. If it means if they haven't done their income taxes because they can't afford it or don't know how, doesn't necessarily mean that they're incapable. They just may need some help. Certainly, I don't do my own income taxes, so I don't believe it necessarily makes someone incapable. And we also can't force someone to give back money that they may have taken from an incapable party. So if we become the guardian for finances and there has been some sort of financial abuse, we would have to use that person's money or see what money they have that's available to take any legal action against someone else. I mean, calling the police is an option at any point for any of the folks involved. And certainly if we become guardian, we also have that option. And sometimes we do contact the police. And sometimes through that process, there can be, what's it called, when they restore the funds that have been lost or make an order for the funds to be paid back by the accused or the alleged abuser. Our office, though, can only take steps to do that if the person has the finances to pay for the legal steps that are necessary for that. So again, we are more about protecting the person and their finances from here forward, and then looking at what they have in order to meet their needs. We also can't punish the people who may have taken advantage. Again, that's the police and the criminal justice system to look at that piece. So again, remembering that we are not a crisis intervention team. We have time, we have lots, we're very busy. I mentioned at the beginning of this is one of the types of investigations that investigators deal with, but we also go out and do physical searches for when we're the guardian of someone who's incapable, to try and find information about their finances, to find their next of kin, to find out where they bank, to find out, what's the state of their property. Physical searches. That's one of the other things that we do. There are several tasks that we complete as investigators. So we aren't crisis intervention. We don't have the authority to, remove someone from a home without, without authority, without guardianship, basically. And the police or the hospital or ambulance are really where those calls need to go, maybe in conjunction with us. And again, we have to be the last resort. We only operate in the civil justice system, not in the criminal justice system. We can't lay charges. So again, that's turning to the police may be important in those areas if it's believed that a crime has taken place. Okay, I whizzed through that very, very quickly. So here's the list of brochures which are available on our website. And the Capacity Assessment Office link is at the bottom. And I believe on the next slide, there's also some phone numbers. So this is where you can call or email or mail to make an allegation or fax. This is our investigations unit contact. And again, this is kind of a nice one-page piece to have handy if you think you need to call our office, because it also gives you what you basically need to tell us. We need their name, date of birth, address. We need your information, of course. And we need the information about the alleged cognitive incapacity, the financial or personal care risk, and what alternatives have already been tried. And remember, you can tell a story when you call us or when we call you back to tell us, to explain what's happening. So yeah, there's some other phone numbers. And okay, about 12 minutes left for questions, which I'm sure there are many.
Thank you, Denise. Oh my goodness, there are many questions, and just a very quick, huge thank you. The chat box was lighting up with so many wonderful comments and feedback. So I'm going to get right into some of the questions. I'm sure we won't be able to get into everything. So we're going to look at, as if you briefly touched on saying, of course, you know, your role isn't there to be sort of the navigator between the family. So many questions have come up about, you know, what does the PGT do when in the case of family dynamics, if there's lies, there's bullying against the POA, what would you do? How could you step in? And there's many different situations that people did speak out on a personal level. So maybe if you could just sort of highlight a little bit again, the role and what PGT would do or can do.
Well, we can only do basically the steps that I've explained to you. We can only get involved if there's serious risk to the individual. We can't get involved if there's family dynamics where family members are bullying the POA, unless that puts the allegedly incapable person at risk. We can only investigate the allegedly incapable person. That's the only person we can gather information about. We can't go searching for information about the POA or the other family members. The only way we could get POA information is in their, you know, as they're in their role as the attorney for the allegedly incapable party. So what we would probably do is encourage the power of attorney to get proper legal advice from an estates and trusts lawyer. Getting the right legal advice, I can't say enough how important that is, because too many times people have said, you know, I've gotten legal advice, and they, you know, the woman who was told to resign by a lawyer as power of attorney for property and personal care and to call her office because her family member wouldn't stop smoking in common areas. You know, so estates and trust lawyers, the Law Society of Ontario has a directory of specialists, and you can see there who has that specialization. They have health law, estates and trust law, family law, you know, other areas of law. That's where you can find the list of lawyers who have estates and trusts expertise.
Thank you. Quite a few questions came up about asking about what's the best approach for getting funding to cover the cost of a capacity assessment if the senior is and has very low income.
Well, I mean, one of the things I forgot to mention is that the person can also request the assessment themselves. So if, you know, if you're concerned about your grandmother and she, you know, she may be not capable of managing her finances, but maybe she's aware enough to know that she needs the help and wants the help and wants to request it herself. That can happen, and it has happened. She must be capable enough, and she then could also apply for the subsidy with probably with some assistance. They must be capable enough to go through whatever that process is, and I'm not involved in that process, but they must be capable enough to understand, I think, probably what they're asking for and what it means in order to request themselves and get a subsidy. In terms of finding, excuse me, the funding, I don't have the answer to that. I mean, I've seen certain organizations in one area pay for the Section 16 capacity area, Section 16 capacity assessment, and then in another area of the province, same organization, they won't pay for it. So it's really hard for me to say, but I would just say, you know, keep asking around. I mean, if there's any family or friends who together may be willing to pool their money, that may be helpful. Sometimes people can, if we do become guardian, and again, you want to be fairly confident that they're going to be found incapable before you take the step, right? That they're incapable of managing their property. If we do become guardian and someone submits a bill to us, if the person has the funds to be able to pay for it, we may be able to pay for it. We may be able to pay for that bill. But there is absolutely no guarantee that we would do that, because we'd have to look at what's the state of their finances, what are their needs, and can they afford it?
Perfect, thank you. Quite a few questions have come up regarding during COVID restrictions right now and being unable to find someone to come to hospital because of the situation of COVID. Do you have any suggestions for patients in hospital that are needing a capacity assessment during this time? What can we do?
So is it two questions about how to get them to hospital or how to get them assessed in hospital?
Sorry, they're in hospital, how to get them assessed because of the COVID restrictions.
So if they're a psychiatric patient in a Schedule I hospital, basically a hospital with a psychiatric ward, the hospital must do it under the Mental Health Act. It's under the law. Okay, so good. If that's the case, you may wish to contact the hospital or maybe contact a lawyer yourself to help you remind the hospital of that situation. If they're not a psychiatric patient, and if there are concerns about getting the assessment done because they're in hospital and they're not allowing visitors, I know it has been done virtually during this COVID period. I think probably each assessor is an individual contractor, and they make, they decide for themselves what they are going to be able to do. And of course, like I said, I've known that some Section 16 capacity assessments have happened virtually during the pandemic. So that may be another option to look at with the assistance of someone from the hospital. But again, the person has the right to refuse, and whoever arranges for it pays for it.
Perfect, thank you. A lot of questions talking about what if a client refuses to participate in a capacity assessment, even though the evidence medically has proved and provided that showing that they do need one?
Well, that might be the time to call our office if there's also serious risk. There must also be serious risk for us to get involved. And of course, if it's for personal care, there must be something that we might be able to do to assist. So, and I think someone asked as well, how do you get someone to do an assessment if it's court ordered? Sometimes it means finding the right assessor with the right personality. Maybe it means them going back a couple of times. Like, it really depends on the reasons that the person's refusing it. Some people they're just ornery and just will have none of it, never have, never will. And other people, it just takes the right, the right steps, the right people, and the right approach.
Very true. Excellent. What about suggestions for someone who is quite capable, but does not have any friends, any family around them, and would like to use the PG&T as a trusted source for helping them pay all their financial bills? Is that possible?
No, even though I mentioned earlier, someone can, may be able to appoint us as power of attorney for property only. There are strict rules about what happens if and when that happens, and the PGT himself must agree to it. So it's very, very rare. The person must be capable at the time to appoint us, and there's a bunch of other steps they have to take. But basically, if we become guardian, and we take over. It's not a partnership. That doesn't mean that, of course, we're going to disregard what the person wants or needs. We have to consider that. And even if we're guardian of someone who's incapable, we must try and determine what their wishes may be. But the decision is ultimately with us.
Perfect, thank you. And I know we're just at 5 minutes left, so I'm going to just turn it back over to Rayanne to finish up the rest of our session. We do have still quite a few questions, but I've been trying to answer a few offline as well, but we'll try and make sure we get to everybody. There's quite a few personal stories that people share with us. So thank you so much for doing that. And we will get back to everyone. And again, thank you, Denise. Fantastic presentation. Thank you.
Thank you.
Thank you both for, thank you, Denise, for the presentation. It was very informative. I always learn something new every time I hear the presentations, and for everyone's questions. So just to wrap up, there was some questions about where to access the presentation. So the PowerPoint will be put into a PDF onto the website, and the recording posted within the next day or so, and you will receive an email accordingly through the Zoom account. So people who want additional supports, I know that Denise alluded to some of those, but again, she had mentioned about referring or talking to the police about wellness checks. You can obviously call your local police department. Some of the officers or some of the police departments have specific officers, and if not, just ask for an officer to do a well-being check. The Crime Stoppers, you can report anonymously if you're concerned about the safety or well-being of an individual, particularly if they're at risk and are incapable. You can call Crime Stoppers and report that anonymously. Again, just in terms of reporting, we do encourage people, and by law, if you're within a facility or work within a facility, it is mandated to report within long-term care and retirement homes. So calling the retirement home regulatory authority or the long-term care action line. They also do investigations in regards to abuse and neglect. And in terms of legal, I know that Denise had mentioned a couple, the Law Society, the Referral Service. It's a great resource. You can actually get 30 minutes of free legal advice. And also the Advocacy Center for the Elderly is a great resource for information and advocate on behalf of individuals. I'm part of Legal Aid Ontario. Obviously, United Public Guardian Trustee. We also include the Human Rights Tribunal. There also is a clinic with the South Asian Legal Clinic who provides services as well, which is funded through Legal Aid Ontario. And we've had presentations in the past. So there are some services that you could get linked up to, and if not, you can connect with your local legal in your own area as well to get some, just maybe some basic information that you might require. And then just some supports in terms of home care, contacting the local health integration networks for home care, or CCAC, it used to be called, the Alzheimer's Society. There's many agencies in Toronto, but I know the Family Services in Toronto has an elder abuse program and support and services. There's Pat's Place, which is the shelter there that is available for older adults in Toronto, that they authorize and organize that. And also support for our 2LGBS, LGBT, sorry, 2S community. The 519 or Rainbow Health Ontario is another really good resource to support older adults as well. And they've been doing a lot of work advocating on behalf of older adults and in long-term care as well. So I would welcome everybody to join us, share. We post everything on our Facebook and social media accounts. We do have an upcoming webinar next week as well as the week after to continue our capacity series. And we have a panel discussion on the 24th with experts talking about a scenario similar to what Denise was talking about, risk and capacity, looking at from different experts within the healthcare field, including the LINS, geriatric psychiatrist, a capacity assessor, etc. So that should be a good webinar. So watch out for that. It'll be posted very soon. Again, thank you everybody for attending. You will get that pop-up after the presentation to do the evaluation. We do appreciate that. And again, for those who have questions that we didn't get to or want further concerns that you want to address, you can reach out to our organization or through our website to the consultants, or email us, and we can be pleased to further assist and provide some resources and information. So again, thank you, Denise, for your time. We really do appreciate that. And for everybody who joined us, and we look forward to you joining our future sessions and webinars. So thank you, everybody.
Thank you so much.